We'll go on the record in People versus Ronald Higden, case number 236488. Mr. Higden, podium there, please.
It's an AG case, Judge?
Yep, and the AG is connected here. Hey, Mr. Huda Coker, are you able to hear me okay?
Yes, Your Honor. Yes.
Okay. So we have the AG present. Mr. Higden's present here in the courtroom today. Mr. Brown's here on behalf of Mr. Higden. This was set for hearing. Mr. Higden was initially placed on a delay on a child support failure to pay case, and it appears that Mr. Higden has not been able to comply with the terms of that delay. Mr. Huda Coker, did you receive the updated report that was prepared by Probation and Parole?
Yes, Your Honor.
Okay. And Mr. Higden, did you have a chance to go through that with Mr. Brown?
Yes, Your Honor.
Okay. Mr. Brown, are there any corrections that need to be made to that?
No, Your Honor.
Mr. Huda Coker, were there any corrections that you need to have made to that updated report?
I did not see any corrections, Your Honor.
Okay. Mr. Huda Coker, did you have any allocution, and what are you asking the court to do today?
I believe there's Amanda Doyle that should be present in the courtroom. I think she may wish to make a statement.
All right, Ms. Doyle, did you want to make a statement today? Okay, Mr. Higden, if you could have a seat next to your counsel. Ms. Doyle, you can come forward to the podium, please. And can you state for the record your relationship to this case?
I am the kid's mom.
Okay, but what is it that you would like to say?
With the non-support, it causes a financial hardship and extra stress on both the kids and I. The kids don't get to go out and do as many outings and activities. The cost of raising the kids is well over what's ordered, and he's not being held accountable for it. Lily's gone through 2 wardrobes since August, September-ish. She's grown over summer and needed a whole new outlet fit wardrobe for summer for the school clothes. And then she's recently had a growth spurt where I had to go out and buy a whole new wardrobe for her. Ronnie has an unusual habit of ripping through all of his jeans. He goes through at least a pair a week just because he rips holes in them. So I've had to replace his wardrobe twice since about August, September. Child support helps us with the unplanned spur of the moment expenses. The kids have trips down to DeVos and Traverse City for appointments. And the child support helps to cover those unexpected expenses of having to go to those appointments. It makes those appointments a little bit more comfortable and manageable for the kids, and they can end up doing some more activities and things while we're at those appointments. As a single parent, my work availability is limited to match my childcare availability, which keeps me from being able to pick up overtime to help cover the offset of those unexpected expenses that do happen suddenly.
Okay. All right, thank you. Mr. Huda Coker, anything that you wanted to say for allocution today?
I'll just add briefly, Your Honor. Since Mr. Higden was placed on a delayed sentence, his last payment was in October of 2023. He does have a monthly obligation of $925 a month. So he was given the opportunity that not only addresses arrears, but earn a reduction in charges. However, he has made 0 payments since October of 23. And given that, the people would ask that the court consider imposing a jail sanction, given the payment history thus far here. Thank you.
All right, thank you. Mr. Higden and Mr. Brown, if you'd like to come back to the podium, please.
Your Honor, if I could briefly approach.
Yes.
I did not have time to give this to Mr. Coker. It's just a text from his employer. I can send opposing counsel a copy if you would like one.
Okay. Anything that you would like to say on Mr. Higden's behalf, Mr. Brown?
Your Honor, Mr. Higden was incarcerated, I think through June, July, and August for 3 months. That caused some employment issues. He was previously paying $417 a month. That amount was apparently raised while he was incarcerated, so it more than doubled. Obviously, upon release from incarceration, sometimes it is difficult to find employment, but he did get this plea offer in the beginning because he did bring down those arrearages a significant amount. And prior to his incarceration, I believe that he was paying that $417 a month, and also some in addition to help bring down any other arrearages that would be left. So the fact that he has just recently obtained some very good employment, which he does have a steady job and could help to pay that down even more. I would ask the court to take those things into consideration when considering a jail sentence. It is going to do nothing to help the children out other than deprive him of meaningful and gainful employment at this time. And again, the amount, which apparently in speaking with Mr. Higden was a big surprise. I don't know if he got notice of the change or anything like that, but when you more than double something, it is a tremendous burden, financial burden. I understand how the system works here as far as this is all a formula based on many different factors. But I would ask the court to take those things into consideration when imposing incarceration. And if the court would be so inclined, in order to keep his employment and at least provide something to child support, which he apparently is now able to do through that employment, consider an alternative sentence.
All right, thank you. Mr. Higden, was there anything you wanted to say?
Your Honor, when I go to jail, I can't even try to pay this. I'm doing my best. I finally got steady work. And that's about all I can really tell you. I mean, yeah. I don't know.
Okay. All right. Well, I read through the original report. I'm familiar with the circumstances here. I also read through the updated report as well, which indicates that there's still substantial amounts owing, and that those amounts have been going up. And the deal is what it is, and it's required to make certain payments. And if you didn't make them, you don't get the benefit of the deal, and that's really all there is to it. But having reasons for not making them isn't part of the consideration. So, I'm really in the position where you haven't followed through for whatever reason, and it is what it is. So at this point, the court's in the position of imposing the jail time that it didn't impose because of this arrangement ahead of time. And I don't have an objection if you qualify for the work camp program through the jail. That would give you an opportunity to remain working while you're serving your jail time.
Right, Your Honor. So I would be, yeah. So we're gonna go 6 more months of me not being able to pay it.
Well, not only have you not paid it, but you now owe $4,000 more than you did when this started. So I should give you 6 more months to just not make any more payments. I mean,
I promise I will make the payments, Your Honor.
Not only have you not made the payments, but you owe $4,000 more than you did at the start. So why should I think that just because you're standing here telling me that it's actually going to happen? Right? I mean, nothing's happened over the past year to improve the situation. It's only gotten worse. So how is it going to magically start getting better now if I don't put you in jail?
Because I have a good job now.
Okay, well,
I do this, I'm gonna end up losing that job, Your Honor.
at some point you got to pay the consequences for what's going on here. And if you're not paying child support, then the only other option I have is for you to be in jail. And you haven't been paying support, and you've been racking up more money on top of it. So at this point, there's just absolutely no reason for me not to impose the jail time. So the court is going to order that you serve 6 months in the Otsego County Jail. You have credit for 2 days served. The court's going to order that any fines and costs imposed at the time of the delay be reserved. You have the ability to appeal this sentence, Mr. Brown, if you can provide Mr. Higden and his appellate rights to this.
Your Honor, he would acknowledge that.
All right, thank you, Mr. Higden. You're amending us in the comment.
Thank you.
Mr. Whitaker, anything further today?
I do have Rachel Gan scheduled for 2 p.m., Your Honor. So,
We can do that right now.
Okay.
Even though it's
Is Gan present?
no.
Oh. We need to give her a let's go on the record in People versus Rachel Gan, case number 236641. Mr. Brown is here in the courtroom on behalf of Ms. Gan. We have Mr. Whitaker present by video. Mr. Brown.
Your Honor, may I approach?
Yes.
And again, I just received this today. Actually, it was sent to me at 12:38. Scott did call me earlier today, told me she wasn't going to be here. I did reiterate to her the policies of the court. She said she was having back pain, could not make it. What I tendered to the court was a letter from her doctor. Other than that, I've had good communication with her.
All right, Mr. Awuda Coker, what I'm looking at here for your information and for the record is purports to be a medical record from a doctor in Wayne, Michigan, indicating that Ms. Gan had exacerbation of back pain yesterday while working, and that the doctor is saying she should not travel for 4 hours as needed for her court appointment today. So that's what I have. It's, I mean, it just at first glance, it appears to be generated from a medical practice, but I have no idea how much weight we could put on that. In light of that information, Mr. Awuda Coker, do you have any position on how the court should proceed today?
I would request a bench warrant, Your Honor. My notes do indicate that at the last hearing on this case, Ms. Gan reportedly had car troubles and couldn't attend. So it appears that she has a new excuse for each hearing. So the people would request a bench warrant.
Brown?
I would request a show cause, Your Honor.
All right, Mr. Whitaker, I think I agree with you. Given her failure to appear last time in February, even if this is a legitimate notice from a doctor, it's clearly last minute, which gives me some question as to whether or not this is a legitimate injury or whether this is a last minute thing that she's done in order to try to avoid court today. So for those reasons, the court finds it would be appropriate to issue a bench warrant. Mr. Whitaker, I'll ask that your office prepares that. The court will order that her bond be revoked, and we'll proceed further once she's arrested and brought before the court.
All right, thank you.
Anything else for the record on that file, Mr. Whitaker?
Nothing further, Your Honor. Thank you.
Mr. Brown?
No, Your Honor, thank you.
Okay, thank you. Mr. Whitaker, you're free to disconnect at this time.
All right, thank you.
People versus James Morris. Case number 246685.
Thank you, Your Honor. For the record, my call behalf of the people.
Larry Brown on behalf of Mr. Morris.
Mr. Morris, you come right to the podium there, please. How do we want to proceed on this file today, Mr. Brown?
I just want to brief moment, Your Honor. There has been a plea offer made in this matter, and it is my understanding that it would be a plea to count 2, which is a CSC second degree, first under 13, and an added count 6, which is CSC first degree under a PAC code of 750.520B1A, which is a life offense, but it does not require the 25-year mandatory minimum, and the remainder of the information would be dismissed.
Next question, Your Honor. The added count 6 is the criminal sexual conduct of the first degree victim under 13, contrary to MCL 75520B Baker 1A Adam.
All right, is the factual basis the same as count 1?
Yes,
That's
Judge.
what we would.
The only difference would be it doesn't come with the mandatory statutory 25-year mandatory minimum.
All right, Mr. Morris, have you had a chance to talk to Mr. Brown about this plea arrangement?
I had spoken with him on the phone.
You made a decision about whether you want to accept that agreement today?
Yes, sir.
You want to go forward with that agreement?
Yes, sir.
Do you need more time to talk to Mr. Brown today before we do that?
I would like to speak to him in person if I may, sir.
Okay. Yep, I'll absolutely give you an opportunity. You just want to have a seat. When we take a break, I'll give you a chance to talk to Mr. Brown and then
Thank you, sir.
proceed further. People versus Munzel, case number 246678.
The record, Your Honor, my call behalf of the people.
Larry Brown on behalf of Mr. Munzel.
Mr. Munzel's present here in the courtroom today. Mr. Brown, how do you want to proceed on this file?
Your Honor, may I have just one moment?
Yep.
Your Honor, there has been a plea agreement in this matter, in which Mr. Munzel would plead guilty to count 2, count 3, and count 4 for dismissal of the remaining counts and enhancements.
Mr. Rolla, is that a correct statement of the offer?
That is correct, Judge. And of course, if there's any restitution involved, that's included as part of the plea agreement. Also, the weapon in question, in this case, the 380 Ruger, I believe a claim has been made for its lawful owner. So it's not one we would normally we would ask that it be confiscated and condemned under 75239. I don't believe that's going to be the case here.
All right, Mr. Munzel, have you had a chance to talk to Mr. Brown about this plea? Is that how you want to proceed today?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Mr. Munzel, are you currently on any probation or parole? And you understand that by pleading guilty to count 2, which is larceny of a firearm, that's a maximum penalty of up to 5 years and or a $2,500 fine.
Yes, sir.
And count 3, which is retail fraud first degree, maximum possible penalty you could face. Who's got a phone on that's dinging? Who has that? Okay, ma'am, can you leave the courtroom, please? And you can return once your phone is turned off.
I thought it was, sorry.
I've heard it dinging more than once. Everybody should know, when you come into a courtroom, turn your phones off. It's not that difficult. All right. Retail fraud first degree, you understand that's a maximum penalty of up to 5 years and or a $10,000 fine.
Sure.
And count 4, which is carrying a concealed weapon, that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine.
Yes, sir.
With all of those maximum possible penalties in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights,
Yes, Your Honor.
and you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to appeal it or get it reversed, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've talked about here in court?
No.
Is it your own free choice to enter these pleas?
Yes.
Are you pleading guilty to each of these crimes because you are guilty?
Yes, Your Honor.
I have in the information here that this occurred between December 13th and December 21st of 2023. Is that the correct time frame?
Yes, Your Honor.
At that time, were you present here in Otsego County?
Yes.
And did you take a firearm that belonged to an individual named Judith Sayre?
Yes, Your Honor.
Okay, what kind of firearm was that?
That was a 380 Ruger.
Okay. And was it your intent when you took that firearm to put that to your own uses or to sell it or something?
Yes, Your Honor.
Okay. Did you have any permission from Miss Sayre to take that weapon? And did you get pulled over or something when you had that?
No, they came to my home and asked me about it, and I gave it up.
Okay. How about the instance when you had the pistol in your Jimmy? Is this part of the same
They just
thing?
assumed because I stole it when I was at Kohl's and brought it home, that's why I got the concealed carry for the transporting it.
Okay, okay, so you stole that gun at Kohl's and then transported it home
Yes.
in your vehicle?
Correct.
Okay, and you didn't have it locked in a case or anything like that? At the time that you did that, did you have a concealed pistol license or anything else that would have given you the authority to carry a weapon in that way?
No, Your Honor.
As part of the same transaction, well, did the retail fraud at Walmart happen on a different day?
It did, so when they came to my home to find the pistol, they found stolen merchandise too, and told them everything
Oh,
right there. So,
okay. Was that taken from the Walmart here in Gaylord?
yes, Your Honor.
And did you have any permission to take that property from Walmart without paying for it?
No, Your Honor.
Mr. Rolla, do you have any further questions or are you satisfied with the factual basis?
Judge, as to company that's a retail fraud's first degree, I'm sorry, I don't know if I heard the court either give the amount.
I did not. Do you have any reason to doubt that the amount or the value of the property that you took from Walmart would have been more than $1,000?
And with that addition, Judge, people are satisfied the court's sufficient factual basis to accept defendant's pleas to count 1, the larceny firearm, count 3, the retail fraud first degree, and count 4, CCW, or in this particular case, transport pistol in motor vehicle.
Mr. Brown, are you satisfied with the factual basis?
I am satisfied with the factual basis as well as the court's compliance with statute and court rules of taking pleas, and I am not aware of any threats, promises, or inducements not placed on warrant.
People are satisfied the court's applied the court rule statute, aware of no threats, promises, or other inducements not placed on the record. Thank you, Judge.
Thank you. All right, Mr. Munzel, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. You're going to meet with Ms. Davis before you leave court here to set up a pre-sentence report, and then just make sure that you stay in touch with Mr. Brown prior to the sentencing hearing.
Was it to count 2, 3, and 4? Because Mr. Rolla said count 1.
2, 3, and 4.
Okay, you said count 1. I just want to make sure I had it
My
correctly.
apologies, yeah.
Okay.
Count 2, the felon
Thank you.
larceny of firearm. Count 3, the retail fraud first, and count 4, carrying a concealed weapon, or in this case, transporting a pistol in a motor vehicle.
Okay, thank you. That's all for today, Mr. Munzel. People versus Deborah Wells Kibby, case number 46680.
Reverend John, I call that people.
Third round, we have Ms. Wells Kitty.
You can come right after the podium, please. Record should reflect Ms. Wells Kibby is present here in the courtroom today. Mr. Brown, how did we want to proceed with this case?
Your Honor, this is a relatively new case found over on January 11th. There has been a plea offer in this matter. I've gone over that offer with Ms. Wells Kibby. At this time, we would request a brief adjournment. She is still considering that offer.
Mr. Rolla.
It's a relatively new case. People don't have an objection to an adjournment.
Okay, Ms. Wells Kibby, the court's going to set this for a hearing in about 30 days. Between now and then, I'll need you to discuss the plea offer with Mr. Brown. And when we come back at that time, I'll need to make a final decision about whether you'd like to accept that or not. Okay. Mr. Roll, anything further on this file today?
Not this file. Thank you.
Mr. Brown?
Nothing further.
Ma'am, did you have any questions?
No, thank you.
Thank you. That's all for today. People versus Avery Campbell Bella, case number 246672.
We have Ms. Herbella. Your Honor, may I have just one brief moment with Ms.
Yes.
Herbella? Thank you, Your Honor.
Record should reflect this Campbell Bella is present here in the courtroom. How did we want to proceed today?
Your Honor, there's been an offer by the people in this matter to plead count 1 for a dismissal of count 2, and we are going to take advantage of that offer.
I just add one thing to that. We're also going to dismiss her district court file 23-42444A-SM.
That is correct, Your Honor. I apologize.
Okay, and Ms. Brucker, otherwise, is that a correct statement? Yeah.
Yes, Your Honor.
Ms. Campbell Bella, have you had a chance to talk to Mr. Brown about this plea agreement?
Yes.
And is that how you want to proceed today? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Ms. Campbell Bella, are you currently on any kind of probation or parole? Okay. And Mr. Brown, is this plea going to affect that probation in any way?
She's on juvenile court probation, Judge.
Yeah, I don't think it's going to affect it.
Oh. And you understand that the maximum possible penalty you could face for the charge you're going to plead guilty to is up to 10 years and or a $5,000 fine. With that maximum possible penalty in mind, what did you plead to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights? Do you understand that you're giving up and waiving all of those rights by pleading guilty today? Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to plead guilty? Are you pleading guilty because you are in fact guilty? This happened on October 30th of 2023. Is that the correct date?
Yes.
And on that date, were you here in Otsego County?
Yes, ma'am.
And where did this incident take place at?
225 Lake Drive.
Okay. All right. And that assault, there was an altercation between you and Bonnie Campbell Corbella, is that correct? Okay. Mr. Brown, was there a weapon involved in this, or could you inquire into some of the specific facts of the incident?
There was, I'm not sure if there was a weapon, but there was something that was puncturing the victim's skin. I don't know if it was a traditional weapon, a small pick, piece of plastic.
Mr. Ruger, can you ask some questions of Ms. Campbell or Dog?
Ms. Campbell, were you in possession of a knife during that assault against Bonnie Corbella? And did you use that knife as part of the way you assaulted her? Did you intentionally stab her with the knife?
Are you satisfied with the factual basis based on that testimony?
Sorry, Judge, I didn't know if you were gonna have me continue to ask all the factual
Yeah.
basis. As a result of you stabbing Mrs. Corbella, did she have any injuries? And were you attempting to inflict injuries on her with using that knife? Okay. Do you know what kind of injuries she had? What part of her body were you trying to stab her? Okay. Different parts of her body. And could you just make sure when you're answering your statement loud enough for us? Okay. Just one minute. Larry, do you want to ask her any other questions about the?
I mean, I think, Ms. Brooker, we've got testimony that she intended to cause injury. She was using a knife. I mean, I think we could.
Okay.
I think,
Just the-
in my view, that's enough to infer the intent to do great
Okay.
bodily harm.
That was the only part I was wondering about.
I think the combination of her testimony, along with the weapon that was used, would satisfy that on that. You're free to disagree.
No, I'm satisfied, then, Judge.
Okay. Mr. Brown?
I'm satisfied as well.
Ms. Brooker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Brown?
I am not either, and I believe the court is compliant with statute, court will be taken.
Ms. Brooker?
No, Your Honor.
Are you satisfied the court has complied with statute and court law?
Yes, Your Honor.
Ms. Campbell Hurdella, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied based on your testimony that there is a factual basis to support a finding that you are guilty of count one. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Ms. Davis to set up a pre-sentence report and then make sure that you stay in touch with Mr. Brown, okay?
Your Honor, before we end the hearing, Ms. Corbella on the date this incident occurred was 17, she turned 18 about a month after. This was an automatic waiver case. So I just want to make the court aware of that for purposes of our sentencing hearing. My reading of the statute is that in addition to the PSI, that DHS would need to prepare a social report for the court to consider as well. So I just want to place that on record.
Okay, all right, and I believe you're correct on that. Mr. Brown?
I agree, and I did speak with Ms. Brooker about that.
Okay. All right, Mr. Rooker, anything further for today?
No, Your Honor.
Mr. Brown?
Nothing further. Thank you.
Thank you. Let's take a short recess. Mr. Brown, I'll give you an opportunity to speak to Morris, and we'll come back on the record in about 10 minutes.
Thank you.
Mr. Morris, have you had further opportunity to speak with Mr. Brown today?
Yes, sir.
Okay. And did you want to proceed with that, the agreement that you're speaking with him?
Yes, sir.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Good morning again. Mr. Morris, are you currently on any kind of probation or parole?
No, sir.
Right, and you understand that by pleading guilty to count 2, which is criminal sexual conduct 2nd degree, that the maximum possible penalty that you could face would be up to 15 years, lifetime electronic monitoring, and mandatory STD testing. Do you understand that?
Yes, sir.
And the maximum possible penalty for criminal sexual conduct 1st degree under the provision that you're going to be pleading to is up to life in prison. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand, excuse me, that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the Court of Appeals to hear your case. If they said no, that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
And are you pleading guilty because you are guilty of each of these crimes?
Yes, sir.
Okay, so the information that I have indicates that these instances took place over a period of time between November of 2019 and March of 2020. Is that the correct time frame?
Yes, sir. That's right.
And did all of these instances take place here within Otsego County?
Yes, sir.
All right, at count 2, it's alleged that there was a criminal sexual conduct 2nd degree with a person who was under the age of 13. Is that correct?
Yes, sir.
Okay. And did you engage in sexual contact with that person?
Yes, sir. I touched her.
Okay, where did you touch her at?
Her clitoris, sir.
Okay, and was that for the purpose, was that done for a sexual purpose?
For her, yes, sir. Yes, sir.
Was it a sexual purpose for you?
No, sir.
You didn't do that for the purpose of gratifying yourself
I do
sexually?
not understand how I come to this. Only the circumstances surrounding.
Okay. All right. Was this part of a sexual encounter between you and this individual?
Yes, sir.
Okay. And you knew this person was under 13?
Yes, sir.
Okay. And all right. Mr. Rolla?
Court also would require that we take judicial notice the defendant was over 17 at the time of the offense.
Okay. You were over the age of 17, correct?
Yes, sir.
Are you satisfied with the factual
Yes,
basis?
count 2, yes, Judge.
Mr. Brown? Yes, sir. Okay. Obviously the 1st degree, okay, let's see. With regard to the other incident, did that involve the same individual
Yes, sir.
that was under the age of 13?
Yes, sir.
And did you engage in a sexual act with that individual that involved your tongue going into their private parts?
To the clitoris, sir.
Okay. And again, you knew that child was under the age of 13 at the time?
Yes, sir.
All right. And that occurred in Otsego County?
Yes, sir.
Mr. Roller, are you satisfied with that factual basis?
Yes, Judge, the combined facts for both counts 2 and as given for added count 6, I believe the court has sufficient factual basis to accept defendant's guilty pleas as to both.
Mr. Brown.
I agree, and I believe the court has complied with statute and court rule for taking pleas, and I'm not aware of any promises, threats, or inducements that have not been placed.
Okay. People are also satisfied the court's complied with court and statute as to acceptance of pleas and aware of no threats, promises, or other inducements not placed on the record. Thank you, Your Honor.
All right, thank you. Mr. Morris, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Brown, your attorney, prior to that time. Before you leave today, you're going to meet with Ms. Davis. She's going to set up a time for you to have a pre-sentence interview. Mr. Rolla, anything further for the record on this case today?
Not at this time, thank you.
Mr.
Oh,
Brown.
Judge, one thing, as the defendants now entered a guilty plea to criminal sexual assault involving a minor under 13, the court by statute is required to revoke his bond.
All right, Mr. Brown, do you agree?
I do agree.
Okay, so Mr. Morris, you're going to be taken into custody today. The court is going to revoke your bond based on your plea. And Ms. Davis, are you going to meet with them downstairs then?
One of us will drop a packet off to the jail and then we'll do the interview in the jail, Your Honor.
Okay, all right, very good. Thank you. That's all for today, Mr. Morris.
Mr. Brown.
People versus Elma, case number 236665. Mr. Elma present. This matter was set for hearing at 2:15. It's now 2:30. Mr. Elma has not answered the call of the court. This is set for a sentencing hearing today. Mr. Rolla, any why we shouldn't issue a bench warrant for Mr. Elma's
I'm
arrest?
looking at that now, Judge. Guilty plea was entered back on February 7th earlier this year. He had been lodged previously in Crawford County, but that obviously is no longer the case. I do not know why he is not here. Obviously, he was aware he had to appear. I think a bench warrant is going to be appropriate.
Mr. Brown, have you had any contact?
I have, Your Honor. I'm actually surprised he is not here today. I did bring his PSI for him to go over a hard copy, but I did go over it with him just a couple of days ago. I had a good conversation with him. Again, I'm not sure why he's not here.
All right, the court will order that Mr. Elma's bond be revoked. Prosecutor prepare a bench warrant. The court will, once he's arrested, the court will order that be held without bond so that we can get a sentencing hearing scheduled. And we'll do that as quickly as we can once he's arrested. Anything further on this file, Mr. Rolla?
Your Honor, thank you.
Mr. Brown.
Nothing further, thank you.
People versus Norling, case number 236645 is Ms. Norling. Ms. Norling, you can come right up to the podium, please. It should reflect Ms. Norling's present here in the courtroom today. I can have counsel for your appearances.
Thank you. The record all the people.
Larry Brown on behalf of Ms. Norling.
Okay, this is the date and time set for a sentencing hearing in this matter. Ms. Norling, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that? Mr. Brown, are there any additions, deletions, or corrections?
No, Your Honor, no challenges.
Mr. Rolla, do people have any additions, deletions?
no additional deletions or corrections as to the body report or challenge as the scoring.
Anything on behalf of the people for allocation?
Please, Judge, this is the defendant's third theft offense and the second felony offense. She's a 55-year-old certified nursing assistant with 3 children. He's continuing, at least as of to the report into the probation officer. She had previously been given a delay of sentence on a non-sufficient funds check under $500 for reasons which are not clear at all to the prosecution. She has continued to commit theft felonies. I think significant amount of jail time is probably appropriate. There's a recommendation within the guidelines of 1 day credit. I think the court should follow that. Along with $186 restitution to Walmart for the perishable items that, although recovered, could not be resold. In addition to the over $1,000 of items that were able to be recovered.
All right, thank you, Mr. Brown.
Your Honor, Ms. Norling is 55 years old. She currently is working full-time. She's making a decent wage. She supports her children. She does have a daughter, a son, I believe a grandson. I'm not really sure what happened here, but there's maybe some mental issues going on underneath there that maybe need to be dealt with. Perhaps it was just a hard time for them and they were going through things. But that notwithstanding, the most unfortunate thing I believe here is the way that this is going to affect her family through no fault of their own, especially her son and grandson, who are both minors, could very well end up being homeless. And I know that that is not a major consideration that the court takes into account, but I would ask the court to fashion a sentence that not only deals with this situation here, but that could potentially allow her to continue working if the court were considering a kind of work.
Thank you, Ms. Norling. Anything you wanted to say?
Yeah, I apologize. I accept full responsibility. Either intent, no intent, my actions put me here. After my husband died 3 years ago, they're taking my meds. I have really severe ADHD. I didn't continue taking that. I just asked to just give me a chance to prove I can do this. I didn't follow through my last probation. I paid my fines and everything. It was a misunderstanding at the bank through a loan that they had tacked on the overdraft. And that loan never went through no pay of the bank, none of my finance company that had got the car from originally. I apologize for wasting everybody's time. I just ask not for leniency, I just allow me to keep working so I can support the kids.
Thank you. I did review the report. I reviewed your past history as well. It's reflected in the report. The issues that you've had, as well as the sentences that you've gotten passed. I don't think probation is appropriate here. I agree with the department's recommendation of straight jail. I don't have an objection to you participating in the work camp program if you're eligible for that. I think that's appropriate here. You're clearly a non-violent offender. But I think you need to understand that the more that you continue to do this,
I'm not going to be in any court ever again.
Yeah, you'd be surprised how many times I hear that.
I'm sure you do.
I'm going to tell you something to hopefully impress that point in time. You're getting to the point where your jail sentences are going to get longer and longer, and you're not going to be eligible for alternative programs like the work camp. Because you've been on probation, you've had delays of sentence, you've been sentenced to just monetary fines and costs in the past, and continue to reoffend. And as you do that, penalties get higher and more serious. So I hope that you're sincere when you say that you're not going to be here again, because if you are, you're just going to be spending more and more time in jail. If we have people that are depending on you, they are they're gonna suffer because of you. And so if you don't want that to happen, then you need to keep your nose clean, okay? So the court is gonna sentence you to 90 days in the Otsego County Jail with credit for 1 day served. That's at the lower third of the guidelines. Or lower half of the guidelines. And I think it accounts for your behavior in this case. I think it accounts for your continuing pattern of behavior. The court doesn't have an objection to your immediate release to work camp. And I hope that I don't see you back here again. You do have the ability to appeal this sentence. Mr. Brown's going to give you some paperwork that explains to you what your appellate rights are, as well as how to request a court appointed lawyer to help you with any of the
Okay.
She did acknowledge that, Your Honor, and I am tendering that to the court.
very minutes of the custody to comment at this time. Oh, I'm sorry. The court is also needs to impose $186 in restitution. That's payable to the Otsego County Clerk to be dispersed to Walmart. Crime victims assessment of $130, court costs of $5, fine of $500, attorney fees of $350, and $68 estate costs.
That's my docket.
Sheet for Morris.
It just needs to be held.
Please let me know.
Yeah. It just needs to be held in jail for sense.
I saw you on an episode of Court Camo last week.
Oh,
Keith Ferguson.
oh, yeah. That was a long time ago. Thank you. Next hearing set for 2:45, so we'll take a short recess until that time. right, Mr. Killing, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in People versus Killing. This is case number 226418. The record should reflect Mr. Killing's present today by video from Otsego County Jail. If I could have counsel put your appearances on.
Thank you, Your Honor. For the record, I call the people.
Thank you, Your Honor. Richard Trish, on behalf of Mr. Killen.
All right, we're on the record today for a motion hearing. People have moved to the court essentially rule that the complaining witness in this case is unavailable and for the court to allow the introduction of her preliminary exam testimony in place of live testimony at court. Or at trial rather. I've had an opportunity to review the briefs, both parties, the case law that they both have cited. And so, Mr. Rolla, is there anything else that you want to present?
Judge, our
Oral
brief-
argument.
Judge, our brief lays it out, but it's clear from case law that in this circumstance, the minor victim would meet the definition of unavailability for various reasons. As set forth. One of those is because of her state is unable to testify at the hearing because of a mental or physical situation and or an infirmity and a whole bunch of other reasons. Whether we're referring to the Beverly case, the Duncan case, or a number of the others that I cited, and in fact attached as additional copies to my brief, some of those published and some of those unpublished, but they all come to the same conclusion that under the circumstances, in this particular case, two things. One, the victim is unavailable and so she can testify and so we should transcript. And second, it is not ineffective assistance of counsel to having not made an objection to that because as the court's well aware, it's not ineffective assistance of counsel to effectively file a spurious motion. Thank you.
I'm not sure where the ineffective assistance part.
Well, if there was, if for some reason it's a situation that there was a tried claim that this shouldn't come in and it would be ineffective assistance of counsel to allow it. I'm saying it's not even, Judge, even were that argument to have been made.
Okay. All right, thank you, Mr. Church.
So, Your Honor, I guess I want to highlight a few things out of my brief, and I don't want to be too, I don't want to take too much time as they're kind of highlighted there. But I mean, one, I would point to Barber versus Page, the U.S. Supreme Court case, which identifies that the court can look at the state's actions when assessing whether or not a witness is unavailable. And I think, frankly, that becomes relevant here because what we have is a situation where a witness took the stand and started to testify. I would indicate, frankly, and I think the prosecutor would likely agree, she was about one or two questions from concluding direct examination. I mean, I think there was one additional question the prosecutor was really trying to get answered and couldn't. So to call it unavailability, I don't think is accurate. But what we can look at is what are the things that lead to this point? The prosecutor made no motion, no request for any type of accommodations for the witness. And frankly, having been a party to the preliminary exam, I know Mr. Rolla wasn't, Mr. Fenton was, but I think this was a very predictable outcome, having seen the way that she testified at the preliminary exam, that she was struggling. But he didn't make any request for a one-way screening. He didn't make a request for a support person. He didn't make a request for two-way communication, to have her testify via two-way communication so that she wouldn't be in front of a jury. Now, I'm not suggesting that we would have agreed to those things or that we wouldn't have had a motion to argue about them, but the fact of the matter is he made no attempt to attain any accommodations for the young witness. The other piece that I want to highlight is, I cited a lot of information in regards to different things in regards to the confrontation clause. And again, I want to point the court to California versus Green, U.S. Supreme Court case. Now that's a case that's almost the inverse of our case. So what we have in that case is the prosecutor seeking to bring in exam testimony because the witness's testimony has changed, favorable to the defense. And ultimately, the court there concludes that, look, because the new testimony is favorable to the defense, there's really not a basis to exclude that. But what we have here is the opposite. And I want to highlight some of the changing circumstances from the point of the preliminary exam to the point of the trial, because these will show how we couldn't have possibly effectively cross-examined this witness. It's impossible. We have 5 laboratory reports that come in after the preliminary exam is conducted. None of that evidence was even submitted to the lab for testing prior to the preliminary exam. We have a FOIA from the Gaylord City PD, which identifies, which was not complied with till after the preliminary exam. 10 reports are identified in which that victim is engaged in theft, lying, or fighting with the police. I have, as of a week ago, a new Brady information report that comes in that identifies that this young lady was involved with the Michigan State Police, where they identify in the report point blank that she's lying to them during that report, and that they have history with her and know that she's a known liar and that she's been deceptive to them in the past. And this didn't even occur till February 14th of this year. And then we have probably the most significant thing, which is the revelation 9 months after the case is filed, where the victim now identifies that she's wearing somebody else's underwear during this, which is incredibly significant because the 5 lab reports pertain to DNA that's found in the underwear, which apparently isn't hers. And she never discloses this until it's found that some other person's DNA is on her and she's confronted with that. So, I mean, to allow this transcript in is to effectively eliminate our ability to ask questions about any of these things. But it doesn't only eliminate our ability to question some of that evidence, it eliminates our ability to impeach her, because all the dishonesty, the long history of it with the police, we can't ask about, because hearsay is going to prevent it, because we can't ask her if she made the statement. And she can either agree, she can either accept it or disagree, but until she acknowledges that a statement was made or not, we don't have a basis in hearsay to bring in the officer's statements to impeach her. So, I mean, Your Honor, to allow this testimony to come in this way is to effectively eliminate any way to challenge her statements at all. I don't think that that is within the confines of the confrontation clause. I don't think it's within the confines of what the hearsay exceptions are designed for. And frankly, it's outside of the realm of fairness in the trial. Thank you.
All right, thank you, Mr. Ronald.
Yeah, in regards to that, and I specifically addressed this issue in my brief, citing the cases of Beverly, Bach, Adams, and Gigliotti, the very same arguments that defense counsel is making as to violations of the confrontation clause and so on there. All of those courts specifically held that no, it is not a violation of the confrontation clause. And since those are reported cases, they're binding upon this court. Defense counsel is well aware of that. And again, it's a circumstance where the argument being made, well, we can't cross-examine the victim as to how come these results say something else. They're not, the defense isn't going to question the victim anyway, because that's going to be out of her ability to answer the question. The persons that can be asked those questions, I'm sure will be asked those questions, will be cross-examined, and will have appropriate responses to it, are going to be the law enforcement and the lab personnel who did the testing. So to say that, well, we can't ask the victim about questions that she couldn't answer anyway, quite frankly, isn't really much of an argument.
Your Honor, I mean, I think the $100,000 question in this trial directly needs to be asked of the victim, which is, why were you wearing someone else's underwear, and why didn't you disclose that to the police for 9 months? She can answer that question, and she should.
And they can get that response, Judge, through other witnesses.
Okay, all right, thank you. So I've had a chance again to review the briefs of the parties. We've heard this once, so I've had more than enough opportunity at just what took place at the trial to consider this issue. And it really is a difficult issue, particularly in this case, given how the first trial went. You know, I think, I don't know how much notice the prosecution had as to whether the victim was going to have difficulty testifying or not. I know that my standpoint, I wasn't anticipating that, and the reason to anticipate it, so it was kind of a surprise. And I think to some extent, the complaining witness's behavior throughout and following her time on the stand couldn't have been anticipated by anybody because it was unusual. So it's hard to find any case law that really directly bears on this issue because this circumstance is just so, it's such a unique set of facts. But I do agree that the cases cited by the parties generally stand for propositions of law that are generally applicable to the court's consideration in this case. And there are essentially two questions here. Number one, is the witness unavailable as contemplated under MRE 804A? And if she is, should her preliminary exam testimony be admissible under one of the exceptions under 804B? So there's two questions and they're really separate issues from my standpoint. And I think what the court has to start with, and I know that there were issues raised in the briefs about whether or not the unavailability at the first trial was caused by the prosecutor's questioning and so forth, and whether or not she could be determined to be unavailable because the prosecutor procured her unavailability. I don't think that's accurate. Prosecutor certainly was asking her tough questions in a tough way, and maybe in the prosecutor's view, that was the best way to deal with that witness. He had more experience than anybody else, certainly in preparing the case, to know that. But when it comes down to it, I think the court has to look at whether there was an intent to make that witness unavailable. And I don't think the prosecutor in any way intended his questioning to result in the unavailability of that witness. So I don't find that as a reason to not find that the witness is unavailable. I think the court really is going to be faced with that determination kind of at the time of trial. I don't think the court can make an unavailability determination prospectively, even in light of what happened in the past, because it doesn't mean it's going to happen that way again. So to me, the crux of this motion really isn't even whether or not she's unavailable. It goes to, is the preliminary exam transcript going to be admissible under 804B1 as a prior statement or prior testimony, form of testimony. And there are two requirements that have to be met for that kind of hearsay to be admissible. Number one, the proper testimony must have been made at another hearing, which it clearly was in this case. But number two, and I think the more important issue in this case, is the party against whom the testimony is offered must have had an opportunity and similar motive to develop the testimony. Whether a party had a similar motive to develop the testimony depends on the similarity of issues to which the testimony is presented at each of the proceedings. And the court has to look at factors such as whether the party opposing the testimony had at the prior proceeding an interest of substantially similar intensity to prove or disprove the same side of a substantially similar issue, the nature of the two proceedings, both what is at stake and the applicable burdens of proof, and whether the party opposing the testimony in fact undertook to cross-examine witness in the same way as they may have at trial. If those are met, then I think there's plenty of case law, including the cases cited by the prosecutor, where the court has allowed preliminary examination testimony to be admitted where a witness is determined to have been unavailable. And in particular, one of the cases cited by the prosecutor, People versus Bach, BAK, I think is the most factually on point with this case in terms of what the witness did and what the court did, which was find that the witness was unavailable and that the preliminary exam testimony was admissible. But I think the defendant's argument in this case isn't necessarily that the preliminary exam testimony under any circumstances wouldn't be admissible. I think the defendant's argument in this case is because of developments after the preliminary exam was held that there wasn't that same or similar motive to develop the testimony at the preliminary exam that there would be now at trial. In other words, there's much more at issue. There's much more, particularly with regard to issues of credibility, that the defense would go into with the complaint witness at trial that they didn't and couldn't have gone into with the witness at the preliminary exam. And in this case, I find issues of credibility to be particularly important and crucial both to the prosecution and the defense because of the lack of really any other witnesses and, I mean, really any other substantial physical evidence. I mean, it's really going to come down to whether the jury believes the complaining witness or whether they believe the defense. I mean, that's really what it's going to come down to. So credibility is incredibly important in this. And I read through the preliminary exam transcript. There was some cross-examination by defense and some that would go towards credibility, but certainly the court cannot find that there was a similar opportunity to develop the complaining witness's testimony on cross-exam at the preliminary as there would be at the trial in this case. So the court finds that the preliminary exam transcript would not be admissible under 804B1, even if the witness is unavailable. For the reasons I've stated, and primarily that the defense did not have similar motive and opportunity to develop the testimony exam, and I don't think it would be in the interest of justice or fairness to for the defense to not have the ability to go into the issues of credibility given the information that was developed after the preliminary exam. So the court finds that, again, the preliminary exam testimony is not going to be admissible even if the witness is found to be unavailable. However, the court is not making a finding that the witness is ultimately unavailable. I think what needs to happen is, we'll reset it for trial if we haven't already got new trial dates. I think the complaining witness needs to be subpoenaed. I think the court is going to engage in a much different colloquy with that witness prior to her testimony outside the presence of the jury. I think it would be absolutely appropriate, given what we know about that witness's difficulties in testifying, for the prosecutor to request accommodations such as a support person or a screen. Mr. Trush, you obviously would have an opportunity to object to that and argue against it. But I think that would be totally appropriate for the people to request that. And if the court were to grant those kind of accommodations, I think it certainly mitigate some of the problems that we had last time and allow the witness to get through testimony and cross-examination. The court would also conduct some questioning, as the courts did in Bach and some of the other cases cited by the prosecutor. And then I think the court would have to make a determination at the time, if the witness is still going to refuse to testify, how to proceed. But under any circumstances, given the particular facts of this case and the particular evidence that the defense acquired after the preliminary exam, that it would not be appropriate to admit that transcript as the testimony of plain witness. So I'm going to ask Mr. Trush that you fashion an order that reflects the ruling of the court today. And I don't know, do we have a trial date set?
No,
In this case yet, so we'll need to reset this for trial. The court will set it for final status conference, as the court normally does in the normal course of business, and then we'll go forward. So, Mr. Trush, do you have any questions about the ruling of the court?
I do, and I would request on Mr. Killing's behalf, obviously, he's been incarcerated for a very long time on this. And I would just request that the court set it as soon as we can get it docketed. I would ask, is the court setting a timeline for the filing of motions?
They would need to be filed and heard before or at the time of the final status conference.
Understood.
About 30 days prior to the trial date.
So I would just ask the court to set it at the next available date as soon as we can.
Yeah.
Again, given Mr. Killing's situation.
Yes, Mr. Roll, anything further from your side on this case?
No, Your Honor, thank you.
Okay, thank you, Mr. Killian. That's all for today, and the court's going to disconnect at this time.
Thank you.
Our next matter is Mr. Hiliker. Is Mr. Hiliker present?
He is, we have an attorney general here.
Yep. You come forward, Mr. Hiliker. This is case number 236541, People versus Hiliker. And we have Mr. Awuda Coker on behalf of the people. Mr. Awuda Coker, I've just called the case of People versus Hiliker, case number 236541. Mr. Hiliker is present here in the courtroom today, along with his counsel. And Mr. Trush, how do you want to proceed on this case?
Thank you, Your Honor. I've had an opportunity to discuss this with Mr. Awuda Coker as well as Mr. Hiliker. We intend to enter into a plea today. Mr. Hiliker would be admitting count 1. They would be dismissing count 2.
All right, Mr. Awuda Coker, is that a correct statement of the plea officer?
Yes, Your Honor.
Mr. Hiliker, have you had a chance to talk to Mr. Trush about this?
Yes, Your Honor, yes.
And is that how you want to proceed today?
Yes, sir.
You could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? Thank you. Lower your hand. Mr. Hiliker, are you currently on any kind of probation or parole?
No, sir.
And you understand that the maximum possible penalty that you could face for count 1, which is failure to pay child support, is up to 4 years and or a $2,000 fine. With that maximum possible penalty in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand all of those rights. Yes. And you understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal the plea or get it reversed, you would have to ask the next higher court up, Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to plead guilty?
It is.
Are you pleading guilty because you are guilty?
Yes, sir.
The dates I have for count 1 involve payments of child support between 2015 and 2019. During that period of time, Mr. Hiliker, were you subject to an order from the Otsego County Court to pay child support to Samantha Harding?
Yes.
Okay. And during those periods of time, did you fail to pay support as ordered?
As ordered, yes, sir. I did make some payments, but not as ordered. Yes, sir.
Okay. All right. And Mr. Awuda Coker, did you have any further questions?
No, Your Honor, people are satisfied.
Mr. Trush?
No, Your Honor, defense is satisfied.
Mr. Awuda Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush?
I'm not aware of any, Your Honor.
And Mr. Awuda Coker, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, the court has.
Mr. Trush?
Defense is satisfied.
Thank you. Mr. Hiliker, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of count 1. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave here today, you're just going to meet with Ms. Davis to set up a pre-sentence interview, and then just make sure that you stay in touch with Mr. Trush, your attorney, okay?
Yes, sir.
Mr. Awuda Coker, you're free to request to appear for the sentencing hearing by Zoom if you just notify my office ahead of time.
All right, thank you.
Mr. Awudakoker, anything further from the people on this case?
No, Your Honor.
Mr. Trush?
Nothing further.
All right, thank you, that's all. Mr. Hiliker. All right, and Mr. Trush, do we have Mr. Cesc?
We do not, Your Honor.
At this point, the court's gonna reset that. Mr. Rowland, let me just go on the record here. Okay, we're back on the record in People versus Cesc, case number 236612. Mr. Rowland, do people have any position on how we should proceed in Mr. Cec's case? That was the one from this morning.
Oh, I'm sorry, Judge, that's why you threw me there.
Yeah, we're back. Right?
No, I recall that now, thank you very much. Yes, you're calling about the matter of People versus Michael Edward Cesc, case number 23-62216.
Yes.
Which was scheduled for a hearing this morning at 9:30 a.m. and at the request of the defense counsel was asked to be moved to 3 o'clock p.m. By my watch, it's at now 3:25 p.m. I think it's pretty clear the defendant, for whatever reason, is not going to appear. And since this was scheduled as an in-person hearing because of previous issues, I think the court, in light of defendant's parents, should issue a bench ruling.
I think it's an in-person hearing because Your Honor conducts all the hearings in person. Mr. Cesc is not lodged, at least not to the best of my knowledge at this point. So I don't think there were prior issues with it. I think it's just normal. The court schedules those in person at this time. I would indicate this was set on sort of short notice. This was one of the hearings that was originally set for February 20th. That whole docket was adjourned and moved to today's date. I've had good contact with Mr. Cesc. It became apparent when talking to him yesterday that he did not realize he had court today. That's all I can really say. We tried to arrange for him to get up here. He made every endeavor to do that, but he's notified me it's not possible.
All right, the court's going to set this for a show cause and a plea hearing. I'm looking through the file. I don't see any prior failures to appear by Mr. Cesc in this case. So we'll reset it. And if Mr. Cesc doesn't appear at that next hearing, the court will issue a bench warrant for his arrest.
That seems more than fair. Thank you, Your Honor.
Thank you. People versus Rao, case number 134686.
Ready, Your Honor, thank you.
People?
And good afternoon, Your Honor. I'm Shannon Smith on behalf of Mr. Rao. Would the court like us at the podium here?
Yes, please.
Okay, thank you.
Right. This is the date and time set for a sentencing hearing on probation violation. We previously adjourned, and I did have a chance to review both the probation's report as well as Ms. Smith, your sentencing memo, as well as the people's sentencing memo. So I'd just like to start with the violation report itself. Ms. Smith, are there any additions to that
No.
report?
There are not, Your Honor. Everything is accurate.
Okay. Mr. Fenning, do you have any corrections to that report?
You know, Judge.
Is there anything that the people would like to say regarding allocation?
Well, I fully allocated the last time, Judge. I was asking for the maximum sentence. I'm not going to repeat everything. The only thing I would say is commenting on the defense memorandum. I put all my thoughts in the sentencing memorandum in addition to previously orally allocating. When she says on page 3 that he believed his legal troubles were in the past, I think that we conclusively disproven that. He was told by police officers in other states years ago that he had warrants for his arrest. He clearly would have known that he had warrants for his arrest because he absconded, as his mother even indicated in her own letter, and said that he admitted that he was running from the CSC charges. She also says on page 3 that he also incorrectly believed that his probation issues in this case were over and behind him. That's just simply not true. I think we've conclusively disproven those theories. She says sending him to prison is nonsensical. I think that's insulting to the court. You look at two things for sentencing, someone's prior record and the offense factors. Well, in this case, there's a third thing, and that is his behavior since the offense. And it's been absolutely atrocious. I can't imagine somebody being away longer than him, almost 10 years. So I think under all the circumstances that I previously indicated and what I put in my memo, I think my request for the maximum sentence in this case is justified. If the court doesn't feel that maybe the offense variables justify that, at least his absence for this long of a period of time certainly does justify a prison sentence at the very least in the middle of the guidelines. Thank you.
All right, thank you.
Or excuse me, in the middle of the range, not in the middle of the guidelines.
Okay, because the court would have to depart.
Right, significantly.
Yeah.
So, right, so I think it's the max will be 60 to 90 months, and that's what I'm asking for. The only reason I can see that the court might not want to give the max is because the offense variables aren't particularly aggravating. But again, his conduct since sentencing and was given that opportunity in drug court and whatnot, the length of time he's been gone, and pictures of him with guns on Facebook and everything else justify a prison sentence in this case.
All right, thank you, Ms. Smith.
Thank you. Your Honor, obviously when my client left the state and in the years following, he was very mentally ill. At times he was homeless. He thought it was a good idea to go fight ISIS and buy a plane ticket to go to Dubai. We're talking about a person who was a self-admitted drug addict, had more problems than I think anyone in this courtroom could imagine. And he absolutely blew his chance in drug court. He blew his chance with probation, but it appears and sounds, even from what his family says, the problems were so far out of control that he was left in a position where honestly, and quite frankly, the family thought he was just going to die. Somehow that didn't happen, and he is alive. And over the last couple of years, what's insane and insanely good is that he was able to get his life on track. He began working full time. He's been sober and drug free, met a young woman that he married, has 3 stepchildren with, has another child with, Annie, who's now 2 or just turned 3. He has his mom and dad, his aunt and uncle who are supportive. And as much as Mr. Rao knew there were legal problems, he obviously ran away from when he didn't complete probation, and obviously heard there were legal problems when his ex-girlfriend made accusations about him. He did think those were over. Many years had passed, and it is a little bit crazy to me that he spent time in hospitals and jails and was arrested and investigated by Homeland Security. And no one ever kept him in custody or said, hey, these things need to be resolved. He, as much as Mr. Fenton says he was notified things needed to be resolved, my client believed those things were in his past. He honestly did not know that. He's traveling all over from one state to the next, working 3 weeks at a time in one place, traveling for a week to go home, then traveling again to work for 3 more weeks. Mr. Rao could not have been any more out and about than he was. And so obviously, Your Honor, there were clear mistakes and missteps on my client's part. What I'm asking the court to look at is the fact that the original guidelines were 0 to 13 months. The original sentence gave him a drug court option. And obviously the sentences were for 6 months, 90 days and 93 days to be run concurrent if he had to serve time. The recent recommendation showing that this matter should just be dismissed and disposed of. I would ask the court to follow along the logic of those 3 things. Order that Mr. Rao serve a year in jail. That would add up the 6-month sentence, the 93 days, the 90 days. He's already got credit for 6 months he's been in right now. In addition to that, and separately of that, Mr. Rao is facing far more serious charges as it is before this court. We're going to be back in court on that case on April 5th. There is no doubt Mr. Rao is not going anywhere for any period of time. And so that is why I am saying it's nonsensical to put him in prison at this time. we have a lot more to handle before this court that's going to take some time. And based on the amount of time Mr. Rao has already done, and just looking at the circumstances of that case, it just seems like prison in that case would be unnecessary and overkill. So we just ask that you take those things into account. Mr. Rao does have his mom, dad, aunt and uncle here who are supporting him. They are also just so grossly disappointed to see Mr. Rao's past catch up with him. And they don't make any excuses for the fact that his past has caught up with him. It's just really unfortunate because this is somebody who actually got his life on track when his life was so far off track. He should have just been presumed dead. I mean, for all intents and purposes and everything, he had not going in life.
All right, thank you. Mr. Rao, anything you wanted to say?
Yes, Your Honor. I prepared this letter on my behalf. Excuse me, sorry. I've made many mistakes and bad decisions in my life. I don't know where to begin. I've taken so much for granted. I've lied. Excuse me. I've abused drugs and alcohol. I've burnt so many bridges. Excuse me. I'm not writing this for pity. All I know is that those days are past. And I will never look back to where I once was. Excuse me. I have a great relationship with my parents. In the last couple of years, my father even started telling me he was proud of me. It never dawned on me why, excuse me, until I took a look and realized that I became a man, taking care of my own. I currently have the best relationship with my brother, and if you know our past, that is truly amazing in itself. So many years I've spent blaming others, excuse me, when I have been the one at fault. I just needed to grow up and become the man I was to be. I am now married with a child of my own, who I named after my mother. Excuse me. I have who I love with all my heart. I still have a lot to learn in this life, and I will never stop becoming better. It makes me sick to think how much time I've wasting time. I've pulled myself out of a dark place. So many days gone just because of one person, me. The only positive is that once I started my mental transformation, it led me to my wife, who I love eternally, and vice versa. I made the decision to have a child with her, and I remember holding my baby excuse me, for the first time. Excuse me.
Ms. Smith, if you need to get some Kleenex for him, there's right here on the clerk's table.
Excuse me. I remember holding my baby the first time, thinking this is living, this is life. I apologize for all my wrong, and I'm ready to put this in my past and move forward with my life no matter what direction it goes. I will learn to accept my past, I will handle my present with confidence, and I'll face my future without fear. Thank you, Your Honor.
All right, thank you. I did have a chance to review, as I said before the hearing, the reports, as well as what your attorney filed and what the prosecutor filed. And we adjourned this hearing, so it's given me additional time to consider what the appropriate way to handle this case is. And you know, looking at things as a whole, it's certainly one of the more egregious absconding cases that I've seen in terms of length of time.
Yes, sir.
You know, that certainly doesn't work in your favor. What that tells me is, and I don't believe that you thought that this all just was gone and gone away. I don't think any rational person would think that they would leave in the middle of their probation and just expect that they didn't have to deal with it anymore. You know, I think you left to get away from it. I think you stayed away to stay away from it. And the fact that you had encounters with law enforcement along the way, where at any point you could have said, oh yeah, by the way, I got this issue in Michigan I'd like to take care of. You never did that. So to me, that's shows a motivation on your part to continue to try to evade this. You never returned to Michigan, even though you clearly have family contacts here to take care of it voluntarily. The only reason why you're here now is because a new investigation got opened up into some of your conduct. So, you know, there really isn't any excuse from my standpoint, other than you wanted to evade this for as long as you possibly could, and hopefully forever, probably. which indicates to me that there needs to be a sanction for you for that behavior, not only to punish you for that conduct, which is clearly wrongful, but in particular, as a deterrent, so that you understand, to the extent that you're ever placed on some kind of supervision again, that you can't just leave and pretend that it's gone away and forget about it. It's not going away. And I think other people need to see, we have a lot of people on probation, and I think it, just letting you go here and not imposing some kind of penalty sends a message that you don't like your probation, just move to another state, stay there and never come back. And you never have to pay the price for it. I think that sends absolute wrong message, both to you and to the community in general. The fact that you were doing well, again, I don't find that to be a reason to give you a lesser sentence here. To me, if you're getting all your ducks in a row and you're getting your life in order, part of doing that, part of that process is taking care of the loose ends that need to be taken care of. And if you would have came back to Michigan and said, I'm turning myself in, I've been missing since 2013, I need to get this taken care of, I think the prosecutor has a much more difficult argument to make for the court to impose jail or prison time, because at least evidences that you're trying to get things taken care of and you're trying to move forward with your life and truly get things taken care of. And that's not what happened here. So I absolutely think that incarceration is an appropriate sanction for your behavior over the past 10 years and your efforts to elude responsibility for your actions here in Otsego County. That is going to require a departure, as I indicated, from the original guidelines in your case. The court has to find that there is a substantial reason or adequate justification for departing from the guidelines, and then the court has to find and also state the reasons why the degree that it's departing are appropriate. I don't think a sentence within your original guidelines is appropriate in this case for many of the reasons that I've mentioned here on the record today, as well as the reasons that the prosecutor included in their sentencing memorandum, which I would adopt. An in-guideline sentence, I think, is appropriate for somebody who's going to take accountability for their actions, not somebody who runs for 10 years, tries to evade responsibility. So I think that in and of itself justifies a departure from the guidelines. The prosecutor is asking for the court to impose the maximum under this case, which, the statutory maximum is 90 months. The court can go up to 60 months under the 2/3 rule. I think the court has a more difficult time justifying the degree of departure to the maximum in this case. I think a sentence of 40 months in prison adequately accounts for your actions over the past 10 years in evading your probation in this case. And I think it accounts for some of the other factors that occurred during that period of time. So the court, it is the sentence of the court that you serve 40 months to 7 years and 6 months in the Michigan Department of Corrections. You do have credit for 148 days served. It appears that all the fines and costs have been paid, so there are none of those for the court to preserve. However, you do have the ability to seek an appeal of this sentence, and Ms. Smith, if you can provide Mr. Rao with appellate rights. Mr. Rao, these papers are going to explain to you how to appeal your sentence if you wish to do that, as well as how to request a court-appointed lawyer to help you with any appeal.
Your Honor, for the record, I'm handing over a copy of the papers to my client so that he can go ahead and fill those out and submit those to the court. I do have a question just of logistics. Obviously, my client right now is here. Go ahead and sign that you got this here so I can give it back to the court. Obviously, right now, he's still facing a felony matter. We still they have litigation to go on it. Will he be sent to MDOC right now and brought back and forth for court, or will he be left in the Otsego jail? The only reason I ask is because I've had different experiences all around the state.
As far as I know, he'll be transported to the Department of Corrections.
Okay.
Any non-evidentiary hearings or hearings that could be conducted
They'll
remotely.
put him on through the, okay.
Yeah. And then if we have trial, of course, he'll be transported.
Okay, got it. Thank you. Thank you. Okay, I'm gonna hand back, put down 3, 5, 4, 5.
It's 3-6.
3, 6. looking at the next court date, we have 3 sets.
Judge, I'm informed by probation parole that he's entitled to 210 days of credit.
Okay. Thank you for that correction. The court grant 210 days credit. Mr. Fenn, anything further?
Yes, thank you.
Thank
Judge.
you.
All right, Mr. Rao, you are remanded to the custody of the state at this time.
You said 210, right, sir?
You wanna take this or you want to take it?
All right, Ms. Sharon, are you able to hear me okay?
Yes,
Is that the correct way to pronounce your last name?
it's Sharon.
Sharon, okay, thank you. Were you anticipating Mr. Hutchins joining us by Zoom today?
Your Honor, I did not writ him, and I think I might have advised your staff that I would waive his appearance. Candidly, I can't remember, but I don't require my client's presence for purposes of argument on the motion.
All right, thank you. And we do have Mr. Rolo, the prosecutor, present here in the courtroom today. So we'll go on the record in People versus Hutchins, case number 216030. We have Mr. Roan present by Zoom on behalf of the defendant. This is defendant's motion to correct an invalid sentence, and I did have a chance to review your brief and support, Ms. Sharon, as well as Mr. Rolla, your response. And it looks like, Ms. Sharon, I mean, the crux of your argument centers around PRV 1 and whether or not under those Georgia convictions would qualify as to be scored.
Yes, that's correct, Your Honor. And Your Honor, if I may, I think I can make this somewhat of a brief hearing if I may just have a moment.
Sure.
Your Honor, I received Mr. Rolla's response on Monday and had an opportunity to look at it yesterday. And I never appreciate when opposing counsel isn't intellectually honest in its argument. I think Mr. Rolla is probably correct, and I do want to just make a record. I did what I could to investigate the nature of the prior convictions. You know, I contacted the PSI writer, I contacted the courts in Georgia. I just couldn't get an answer of the nature of the conviction that Mr. Hutchins had. And Mr. Hutchins candidly could not remember the nature of the burglary conviction that he had. Candidly, the case that Mr. Rolla cited, I was unaware of and did not come across it in my research. And even when I looked up the Georgia statute, and I have full Westlaw access, I can't even get the version of the statute that is cited in Stevens. I certainly don't doubt that it's accurate, but I'm not sure without the case for Mr. Rolla that I would have ever come across the earlier version of the statute, even with the Westlaw access that I have, which is kind of surprising to me. So I know that Mr. Rolla thinks I was disingenuous. That's what he wrote in his pleading. But as a defense attorney, I don't have the type of access to prior convictions that a prosecutor or the court might have. And, it is the prosecutor's burden to show that the PRVs are correctly scored. And I just wanted to make sure that Mr. Hutchins was correctly scored. So I never tried to be disingenuous. And frankly, if Mr. Rolla had just emailed me that case, I probably would have just withdrawn the motion. So although the case isn't binding because it's unpublished, I do think it's persuasive. And I'll just leave it at that, Your Honor.
All right, thank you, Mr. Rolla.
Judge, while it's true, and I agree with defense counsel that Stevens isn't published, the case it relies upon, People versus Cruz, is and is binding, 299 Mischief 381 at 391, a 2013 case. Very rarely is it where you can actually come across a case that is not only legally exactly the same, but factually exactly the same as set forth for the very long explanation by the court in Stevens. They laid out all the factors dealing specifically with the Georgia prior statute. And in this particular case, the only difference between the facts in Stevens and the facts in our case, where the prior conviction in our case is 2003, and the defendant's prior conviction is in 2004. But in any case, at that time, the Georgia statute had a 20-year penalty, which would have made it a high severity felony.
All right, thank you. I had a chance again, like I said, to review the briefs of the parties. And I don't think it was an improper issue to raise. I thought there was certainly arguable merit to the question of whether or not those Georgia convictions would qualify for scoring. And I think it's fair to have it clarified, particularly for the record, and particularly given the potential for appeal later on for the motion to be brought at this level. So I thought it was a fine motion, and I thought Mr. Rolla raised a very valid argument, and ultimately I agree with the prosecutor's argument here. I do think it's correctly scored for the reasons stated by the prosecutor in their brief. So the court is going to deny the motion, and because the second part with regard to ineffective assistance is part and parcel of the first part, and the court finds there's no grounds under that to grant the motion either. So Ms. Sharon, I would just request that you prepare an order reflecting the ruling of the court today, and either get a stipulation as the form from Mr. Rolla or submit it under the 7-day rule.
I will get that done, Your Honor.
And Judge, make it easier for defense public counsel, if she merely wants to put an order that indicates the reasons on the record, the motion to correct an invalid sentence is denied, email it to me, I'll give approval and send it right back to her so she can file it with the court.
I will. Your Honor, can you please indicate to me who I would email the order to on your staff?
You can send that to Ms. O'Rourke. She's my scheduling assistant. Do you have her email?
I think I probably should. If I don't, I'll call to get it, Your Honor.
She's the one that you would have contacted to get this date and time for the motion.
Okay. Yeah, I will take care of that, Your Honor. If it's not this afternoon, because I have to get to another appointment, it'll be first thing tomorrow.
Okay, very good. Thank you. That's all for this hearing, and you're free to disconnect at this time.
Okay. Thank you, Your Honor.
That also concludes the